Welcome to our informational series presented by motenanthelp.org and Missouri Legal Services. In this segment, we will discuss what to expect at your first court date for an eviction case in Missouri. If an eviction is filed against you in court, a summons and petition must be served to you personally, served to a household member over 17, or mailed and posted on your door. Review the summons you receive carefully. Check all documents attached to the summons, including the petition containing the plaintiff's claims against you. Familiarize yourself with these papers before going to court. The petition may have exhibits attached that further detail the claims. For example, the lease agreement is usually attached as an exhibit. The petition or one of the attached documents should also tell you the amount of rent your landlord is claiming that you owe. Take a picture or make a copy of each document included with your summons, in case you lose the original packet. When you receive a summons, you should contact a lawyer for assistance if possible. If you cannot find a lawyer to help with your case, plan to attend the court date on your summons. Do not ignore your summons. If you don't attend court, the judge will likely enter a default judgment against you, resulting in an eviction and possibly a money judgment against you. Plan your route to the courthouse, parking options, and the location of your courtroom. If possible, visit the court beforehand to become familiar with the surroundings. Use Missouri's online docketing system, case.net, to confirm your case information and court date. Decide if you want to communicate with your landlord's attorney about the lawsuit before attending court. Sometimes you can negotiate issues prior to your court date, which may make your court visit go more smoothly. If you plan to defend your case, prepare an answer and affirmative defenses before the court date. You must file your answer and then serve it to your landlord or their attorney if they have one, before your first court date. You can serve your answer to your landlord by sending it to them or their attorney by mail or email. To file your answer, visit the clerk's office in the court where your case will be heard. Filing an answer is important if you plan to raise any defenses. If you do not raise certain defenses in your answer, they may be waived, meaning you cannot make those arguments at trial. For example, if your apartment has serious conditions issues, and you want to argue that the apartment's issues should affect how much rent you owe, you need to write down the important facts in your answer and affirmative defenses. If you don't, the judge may not let you bring up the bad conditions in a trial. If you do not prepare and file an answer and affirmative defenses before the first court date, you will need permission from the court to file these items late. motenanthelp.org has a DIY motion for leave to file your pleadings out of time. If you have an emergency and cannot attend court, seek a continuance before the court date. A continuance is a rescheduling of the planned hearing at court. It is best to file a written motion for continuance, which is a formal request made to the court before your court date. You can use the DIY forms available at motenanthelp.org to prepare a motion for a continuance. If you can't file a motion to continue before your court date, you should make some other effort to contact the court about your case, such as calling or emailing the court clerk. If you miss your court date without the court granting a continuance, a default judgment may be entered against you. In other words, you can lose your case simply by not showing up. Arrive to court early, dressed appropriately, and bring your summons, petition, and any responsive documents you prepared with you. Be prepared to spend time finding parking and going through court security. Once you find your courtroom, look for the court bailiff or clerk for assistance with checking in. Most courts have a docket for a particular hearing date and time. The docket is the list of cases that will be heard at that time. It's a good idea to find where your case is on the docket list, but this is not essential. What is essential is that you are in the courtroom when your case is called by the judge and that you announce you are present. Once the docket has been called, judges will often encourage the parties to a case to talk outside of the courtroom about settlement. You can negotiate a settlement if it seems fair to you, or you can refuse if you're uncomfortable. You are under no obligation to reveal anything to your landlord or their lawyer at that time. One common way cases are settled is a consent judgment. This creates a court judgment without a trial. Understand that consent judgments are rarely overturned and have the same power to evict as other judgments. You do not have to sign a consent judgment. For more information on consent judgments, see our Settling Your Case video. If you do not wish to settle, judges routinely grant a first continuance on a case, but may want to set the case for trial right away. This is because eviction cases are considered expedited cases and should be set for trial immediately. If you need time to seek an attorney or gather certain evidence, you need to make this clear to the judge and request reasonable time to do this. After giving you the opportunity to talk with the other side during your first visit, the judge will expect that the two of you decide whether the case will be settled, continued for another status conference, or set for a trial. You and the landlord may have different opinions on what is best for the case. You are both allowed to state your opinion to the judge. The judge will ultimately decide whether a trial date or another status conference is appropriate. If you sign a joint motion or court memo with the opponent, the court will assume you both agree to what it says. Do not sign anything you do not understand and agree with during your court visit. If you have any questions about the document you are signing or its effect on you, you should let the landlord's attorney know that you'd like to speak to the judge about the document. The judge cannot give you legal advice, but can confirm if your understanding of the document is correct. Record your next court date. Make sure you know the date and time for your next hearing and understand if it's for trial or a status conference. In eviction cases, it is common that the second court date is a trial. If your case is set for trial, gather and organize your defense. File any necessary documents with the court and serve them to the landlord as soon as possible. You can serve the documents by mailing or emailing them to your landlord's attorney. The attorney's contact information will be at the bottom of the petition you were served. If your landlord has no attorney, you should send them directly to your landlord. See our video Eviction Trials for additional information about what to expect at trial. Discovery is the process through which you can request information and documents from the opposing party. Ensure you have enough time to complete discovery before your trial date. If you plan on requesting discovery, you can ask the judge at your first court date to shorten the time that your landlord has to respond to make sure you have what you need before the trial. If needed, request additional time to gather evidence. MoTenantHelp.org has DIY discovery documents to assist you. See our video, The Discovery Process, for more information about discovery. If you believe you may need to defend yourself in an eviction proceeding, you can find other helpful resources online at MoTenantHelp.org. By being informed, you can better navigate these legal processes and protect your rights. For more detailed information or legal advice, consider consulting an attorney. The information in this video is not legal advice.